The case of AC and JF versus Her Majesty the Queen and Right of Alberta is a case that's going to be heard at the Alberta Court of Appeal. And the case is about a law that puts many, many young people in Alberta at risk of losing financial and emotional benefits to help them transition into independence and into adulthood. And this law affects young people who were raised in government care, raised in foster care, but are now over 18 and they're just trying to get their lives set up as independent adults. Court needs to determine in this case is whether it should temporarily stop this law from applying due to constitutional issues. The BCCLA is concerned that this law violates Section 7 of the Charter, which protects the rights to life, liberty, and security of the person. The concern in this case is that this law, which puts young people at risk of losing these emotional and financial supports, could affect their life, liberty, and security of the person. So just to take the situation of AC, the lead plaintiff in this case, she is afraid, she's a young single mother, and she's afraid that if she loses these benefits, she's going to be forced to return to sex work, which she does not want to do. And because she doesn't know how else to support herself, she's afraid she's going to lose custody of her child because she won't be able to support her. She's afraid she's going to start engaging in substance abuse again. Under this program, she had the support to not engage in substance abuse. She's afraid her mental health will deteriorate. She has had in the past a history of suicidal ideation, and she's afraid those thoughts are going to return to her. So you can see how profoundly the loss of these benefits can affect highly vulnerable young people in Alberta. And the BCCLA wants to make sure that the court bears in mind that Section 7 can protect positive rights, that our Constitution can protect socioeconomic rights. The program at issue in this case, which provides emotional and financial support to young adults who have aged out of government care, is really critical for young people because the young people who receive these benefits are often extremely vulnerable, extremely marginalized, and grew up in very challenging circumstances. And the evidence in this case shows that this program really helps them find their feet so that they can lead healthy, fulfilling, stable lives despite a lack of support that they may have experienced when they were younger. I'm very proud that the BCCLA is involved in this case because it will have such a profound impact on the young adults who are at risk of losing their benefits through this program. But it's also a case that's at the cusp of development in constitutional law regarding the protection of socioeconomic rights under our Constitution. So I think both for the parties involved and for our legal system at large, this case has important implications, and I'm very happy that we're going to be at the table.